In this podcast, we'll be talking about the communication of an offer. We are still looking at the second of the essential elements for the creation of an enforceable contract, which is offer. And here we consider how to communicate an offer to ensure that it is received and accepted as an offer. And that sounds a bit more simple than it actually is. A couple of things to recall before we start. First, the discussion on offer and acceptance and consensus ad idem, which is a meeting of the minds. If the offeror and offeree don't mirror each other, then there is no contract. It is the willingness for them to be bound by the contract on certain terms, and they have to both be thinking and assuming the same thing under their contract. Second, the discussion on the contract being formed upon the acceptance of the offer by the offeree. So consider two principles together to see how they fit with the communication of an offer. First, the requirement of consensus ad idem plus acceptance of the offer by the offeree. For either of these to happen, the offer has to be communicated. First, we need to communicate before there can be a meeting of the minds and before there can be acceptance. So, the rule here is that a statement is not an offer unless it is communicated and accepted as an offer. In the case of Blair and Western Mutual, the plaintiff, Ms. Blair, worked as a secretary for the defendant, Western Mutual. The board of directors at Western Mutual passed a unanimous resolution that Ms. Blair would be given a 2-year salary as retirement pay. The plaintiff learned of the resolution when she was asked to transcribe the dictation of the minutes of the meeting. So she transcribed the minutes and delivered them to the president, who signed them 2 weeks later. But when the plaintiff did resign, she took the position that she was entitled to the 2 years severance based on the board resolution. And the evidence showed that Ms. Blair had not resigned due to the existence of the resolution. The judgment below found that the respondent did not have to pay the $8,000 because there was no promise made and accepted. There was no change in the existing relationship between the parties, and there was no evidence of any intention to change those relationships to create legal obligations. On appeal, the appellant argued that the resolution constituted an offer to pay on retirement, and Ms. Blair's subsequent retirement constituted an acceptance. Therefore, legal contractual obligation arose. Even if the binding contract had not ensued by reasons of lack of consideration, in equity, the respondent, having been made the promise, cannot now be not bound to pay. So the issues arise. Must an offer be communicated as an offer? Must the offeree be motivated by and act in response to the offer? And the ratio is that there is no contract unless the statement is communicated as an offer. So the appellate panel, consisting of 3 judges, all came to that conclusion, but 2 of them saw it from the point of view of the offeree, and the other one saw it from the point of view of the offeror. McFarlane and Bull said there was no contract because there was no evidence that the plaintiff regarded the communication as an offer. It was communicated as minutes, not an offer. Therefore, the plaintiff did not retire in reliance on the offer. The other judgment said that there was no contract because the resolution was not communicated as an offer. So a resolution was communicated for simply to be typed out, and the communication did not evince a willingness to be bound to a contract. Note that there are ideas of reliance and expectation flowing through this decision, 2 important contract law cornerstones. The next 2 cases illustrate the principle that the offeree, in performing the act of acceptance, must have acted with knowledge of the offer. In the first case, Williams and Carwardine, which had the facts were that the plaintiff witnessed a murder of, quote, a lusty man, and the defendant, who was the deceased's brother, offered £20 for information leading to the conviction. The plaintiff knew of the offer. It was advertised by a handbill in town, and the murderer beat the plaintiff nearly to death to keep her quiet, the plaintiff implicated the murderer, who was later convicted. The plaintiff was motivated by a desire to make peace with God before her perceived death, and the plaintiff knew of and intended to accept the offer. So the court asked, must an offeree be motivated by a desire to perform the act of acceptance? And the ratio is that motivation is irrelevant if the offeree knowingly performs the stipulated act. In the other case, the Queen and Clark, the facts were that the murders were committed in 1926 and the plaintiff was an accessory. The police issued an offer of a reward for information leading to, quote, arrest and conviction, quote, of the person or persons, quote, who committed the murders. Now, one murderer was arrested and the plaintiff gave false evidence to protect the murderers. The plaintiff provided information about the murders later, and the plaintiff had previously known about the offer of the reward, but the reward was forgotten at the time of giving the information. Rather, the plaintiff gave the information in order to clear his own name about the charge of the murder. After that, the second murderer was arrested and the murderers were convicted of one murder. The plaintiff sought their reward after the murderer's appeal was dismissed. And here, the court questioned whether the offerer must know of the offer when performing the act of acceptance. The ratio here is that the motive of the offeree in accepting the contract offered is irrelevant, and that comes from Williams and Carwardine. Another principle is that the offeree cannot accept the offer in ignorance, meaning the offeree must be aware of the offer in order to accept it. There must be knowledge of the offer. So let's look at these two cases. Let's try to distinguish Clark from Williams and Carwardine. In Clark did not act on the faith of or in reliance upon the proclamation. There is a presumption that upon the fulfillment of the conditions stated in the proclamation, Clark was acting in reliance upon it, and by his own words he rebutted that presumption. Quote, I had no intention of doing anything to earn the reward. I first decided to claim the reward a few days after the appeal had been dealt with. Inspector Condon told me to make the application. I gave no consideration and formed no intention with regard to the reward. So very, very clear statement that he was not acting in reliance on the award. So although Clark knew of the reward, it wasn't present in his mind when he gave the information that led to the convictions. And although the plaintiff in Williams had a motive to clear her conscience, thinking she would die, she was found to have known of the offer when giving the information and meant to accept the offer. In Clark, the police said that the conditions of the offer were not fulfilled. The Crown had promised to pay the reward for such info that will lead to the arrest and conviction of those who committed the murders. And the information given by Clark did not lead to the arrest of one of the murderers. It only led to the arrest of one of them and not the other. The other one was arrested later. And the information given only led to the conviction of the persons who committed one but not both of the murders. So the police said that the terms of the reward were actually not fulfilled. Now, let's try to distinguish between the two cases and see if there's a satisfactory explanation. In one case, she gave the information to ease her conscience, and the court still found the intention to claim the reward. They followed the presumption. Remember the presumption. Once you have fulfilled the conditions of the offer, we will presume that you were acting in reliance on the offer. The court there found that the intention to claim the reward was there, therefore the presumption arose. The other, in Clark, he gave information to clear himself from a false accusation. The court did not find the intention to claim the reward. Clark himself had rebutted the presumption as a result of what he said. The issue, though, is that you can argue that even though the plaintiff in Williams did not verbally rebut the presumption, the facts regarding her surrounding her confession did rebut it. Why? Well, she thought she was dying. Can she still have an intention to claim the reward? She says she gave the information to clear her conscience, to make peace with God. So if she's thinking she's dying, can we say that she still had the intention to claim the reward? Doesn't that alone rebut the presumption? Theoretically, an important factor would be the reliance of the plaintiff on the promise. If there is, as a matter of fact, there was no reliance on the promise, and then the pressure to enforce the promise disappears. So practically, should reliance be the switch in these circumstances? Should the hope of the reward be sufficient to justify the payment? Policy-wise, if you look at Williams and Carradine, we have to ask whether the Crown's decision to be so technical in their interpretation of the proclamation wise. The judge touched on whether the proclamation was misleading and illusory. What was the result? Well, the rewards such as these are used to aid in the administration of justice. And if you take an overly technical approach, they will be undermined. The cases cited under these headings are not easy to reconcile, and it seems odd that the police were so finicky about the informant's motives. The important thing here, and any time there is a reward offered, is that the police obtain the information. People may not give information after a case where the Crown argues about the technicality of the wording. It needs to be assumed that the police are not likely to be as particular as contract theory suggests they might be.